forever, so that you do not get unwanted marriage proposals from Australia, although you might. But just wanted to tell you about it. And again, it's something that we take seriously, and we want to make sure that just like somebody could walk into the back of the courtroom, they can click on our YouTube channel. So with that, I'll stop talking and turn it over to much more interesting people. I think we have, from all my reading so far, essentially cross motions for summary judgment. I think that defendant filed theirs first, at least back on February 22nd. And then the response came on March the 18th. So I'm going to ask Mr. Schwartz if he would like to proceed.
Thank you, Your Honor. And I did not interpret their response as a cross motion for summary judgment, but if that's how you're interpreting it, certainly we would anticipate filing a response to that. But first of all, what I'd like to start with is, even if the court believes that there are disputed questions of fact where the court cannot make a determination as to whether the contract was breached, we would still ask the court to make legal rulings on the interpretation of the contract. And the question of what a contract means is a legal question for the court, unless if the court initially looks at the contract and determines that on the face of the contract it's ambiguous. That's step one. Step two would be, even if there is ambiguity on the face of the contract, the court should undertake the statutory and common law rules of construction and then determine whether they can determine the meaning of the contract as a matter of law. And we think that even if there's questions of fact as to whether there's breach, the court can still look at the contract and determine what it means. And really, the most fundamental issue here is whether the contract requires U.S. Aquavac to actually remove any amount of sediment from the lake. And initially what happened is that the contract went out for bid, and it was requesting a bid to remove 18,000 cubic yards of sediment from two lakes. It was 16,000 from the large lake, 2,000 from a smaller lake. And U.S. Aquavac returned bids. And the bids that they returned two different bids. One was a bid that was under the contract terms that were set out for bid, essentially just removing it on based on removing 18,000 cubic yards. They also submitted a bid that was about $150,000 lower. It was still to remove the same amount of sediment, but it was a hybrid contract where certain parts of the contract were based on lump sum. So that included a certain number of geotextile bags where they were going to pump sediment out of the lake and store it into these bags on the shore. That part was lump sum. There was also, once they were removing the sediment from those bags off site, that was lump sum. And then there was a daily rate of $1,800 per day. But the daily rate for $1,800 per day still required them to remove 18,000 cubic yards of sediment from the lake. And that's at the contract at page 66 through 70, you can see that. And even though it's still, they crossed off where it says cubic yards and changed that to daily rate, but it says estimated number of units, that's still there. It says to remove for the larger lake 16,000. And in the deposition of U.S. Aquavac, they acknowledged that that's still part of the contract. And it says estimated number of units, and U.S. Aquavac testified that units means cubic yards. So this is still, there's still a requirement to remove cubic yards here. Now, when you look at the contract, each each area that they're supposed to remove sediment from, it all averages out to 100 cubic yards of sediment per day. So they have 160 days to remove 16,000 cubic yards of sediment from the larger lake. And US Aquavac, in their bid, which is a contract term that becomes part of the contract and that's undisputed, they're estimated 110 days to remove 11,000 cubic yards from the northern cove. And then each other cove, it's similar in terms of days. It all averages out to 100 cubic yards per day. So US Aquavac starts this work in January of 2020. And by around like end of February, at the end of February, Longlake had hired an engineer to oversee this whole contract for them. So this engineer drafted the contract language, sent out the bids, received the bids, and was also supposed to be going out there and essentially just looking to see that the work was done and advising Longlake on whether to make payment. So the end of February, this engineer goes out there and they advise Longlake to make payments for, it was at this point, I think there was 4 invoices. And Longlake paid the first 2 invoices. And within the next couple of weeks, they start realizing that things aren't really getting done out there. So these bags are very large geotextile bags, about 98 feet long by 28 feet wide. And the capacity of these bags is 620 cubic yards. By design, that's all they can hold. And US Aquavac is sending emails to the then president of the HOA telling her how much work is getting done. And at one point he says—
I'm sorry, Mr. Schwartz, who did you say is sending emails to?
This is the president of US Aquavac.
Okay.
So his name is Brian Pearl. And he writes an email to Stacy Soros, who was then the president of the HOA, stating, we're about, and I don't have these numbers in front of me, but I think he's saying we're about 45.6% way through the Northern Cove, which he refers to as what's referred to as Cove CIC1. And so far, he says there's a little bit less sediment than we anticipated. They were supposed to be removing 11,000 cubic yards from this cove. He says we're about 45% done. We've taken out 3,800 wet cubic yards. And he says it's 99% of this has been sand. So around this same time, the HOA president is getting contacted by one of the homeowners who lives around the area where this bag is being stored below the dam. And he tells her that this bag is not filling up and wants to know what's happening. So she starts trying to figure out what's happening. And around this time, she gets a call from John Bryant from Riversand. That's the other company who bid on this project. And he tells her that he's been observing the project and they're not moving sediment out of the lake and into the bag. What they're doing is taking sediment from the northern part of the lake and pushing it into the middle part of the lake. So this contract was not to remove sediment from the entire lake. It was just these 3 coves. And so they didn't have a survey done of the entire lake. They had a survey done of the sediment in the 3 coves that were supposed to be dredged. So Stacy meets with Mr. Bryant out on site, observes what he's talking about. They're just moving sediment from the area that they're getting paid to remove it from and pushing it into a deeper part of the lake. And so she terminates the contract. Longlake HOA hires an engineer to come and measure the sediment that's in this bag. And they've determined that there's 85 cubic yards of sediment in the bag. Now, keep in mind, under the contract, on average, they're supposed to be removing 100 cubic yards per day. There's less than 1 day's worth of sediment in there. And by that time, they had been billed for 59 days of removing sediment. And so initially, the engineer who Longlake had hired, he had basically, he was supposed to be really looking out for their best interests and just didn't get that done. And afterwards, he had commented that, well, the sediment shrinks when it goes into the bag, and that's why you're not seeing as much there. But this U.S. Aquavac had already stated that the sediment in the bag was 99% sand, that what they had removed from the northern coast, 99% sand. Sand does not shrink and swell when it gets wet or dry. And as common knowledge just from going to the beach, it's just, the material doesn't absorb water. And so even if it did, the type of, the difference between what they're claiming to have removed, which was 3,800 cubic yards, versus the 85 in there, it's physically impossible that much sediment could have been pumped into the bag and shrunk down. First of all, that amount of sediment wouldn't fit into the bag. It's only 620 cubic yards can fit. And that's Dan McDougall's expert report that was attached to our motion for summary judgment, explains the capacity of the bag. That's not refuted by US Aquavac. Dan McDougall also explains how sand doesn't shrink or swell. And US Aquavac in their deposition acknowledged that all the sediment that they took out went into this bag. But they claim that it doesn't matter what's in the bag because they're getting paid on a daily rate. They never explain, what happened to the other 3,715 cubic yards that they had claimed to remove. Now, if we were in a situation where we're 59 days into this contract, and they've got 212 days under the contract to finish. And if they had responded by saying, look, we got off to a slow start, we've got equipment problems, we've got personnel problems, we're right in the middle of a pandemic, but we still have time to finish the project, then that might have been a different question as to whether Longlake HOA had a right to terminate the contract. Now, it wouldn't make sense for Longlake to continue paying along the way while they don't think anything's happening, but US Aquavac might have had some reasonable expectation to have at least the amount of time that they're allowed under the contract. But here, Longlake knows that they're being lied to about the amount of work that's being done. They're getting invoices for work that wasn't completed. They're visually seeing that it's not getting done. When we deposed Dariante McCord, who was one of the dredging people working for US Aquavac, he testified that they didn't get anything done. He came on in mid-March. He said when he got there, the bag was completely flat. It didn't look like anything had happened. He didn't think that they had gotten any work done. And he said that they were advised by their supervisor when the HOA president came around to observe to fill up the bag with water, to pump water into the bag from the lake to make it look like they were getting something done. And so the contract is terminated because they recognize that they're being lied to, the work's not getting done. And then US Aquavac demands payment. US Aquavac sues to recover payment for work that they didn't do. And in the meantime, we've identified other projects where similar things have happened. And so our claim involves that's a RICO claim that's not at issue in front of the court right now. But simply put, the work just wasn't done. Now, when you look at what's the response by US Aquavac, they're claiming one of the issues they raised, there's no set amount of sediment that would be removed from the lakes. That's not true because the contract still states 18,000 cubic yards. Again, that's pages 66 through 70. and US Aquavac acknowledges that in the contract that they are required to remove approximately 18,000 cubic yards of sediment from the lake. They acknowledge that it's approximately 100 cubic yards of sediment per day. In the response from US Aquavac, they're claiming that units is crossed off and daily rate is put there. But again, units is cubic yards is crossed off from one spot, but units is still in the contract. And in the deposition, US Aquavac testified that units means the cubic yards. And so in the response brief, US Aquavac also states moist sediment shrinks and dries after it is taken out of the lake, but they don't have any evidence to cite for that. We have evidence from Dan McDougall stating that that's not true, and they don't have any evidence to refute it. And any contention that there's no requirement to remove a specific amount of cubic yards as long as they're out there working is refuted by their testimony. And so contradictory testimony cannot be used to oppose a summary judgment. And the contradictory testimony is the deposition of Brian Pearl, where at times he tries to state, well, it's only a daily rate, and as long as they're out there, they're entitled to get paid. But other places that we've cited in our brief, he acknowledges, yes, it is to remove approximately 100 cubic yards of sediment per day. He says, he claims it's a red herring about the bag. He claims nobody cares what's in the bag. But again, he testified the sediment that they removed went into the bag, and he never explains what happens with it. Now, one of the responses from US Aquavac in their brief is they're saying sand is not muck, but ends up getting
Can I
pumped.
stop you for just a second, Mr. Schwartz, and back up to one thing before you leave that topic? You just said that the law states or is clear that, here's what I wrote down: contradictory testimony can't be used to defeat summary judgment. Do you mean self-serving testimony, or what did that sentence mean?
Yeah. Well, that's prophecy, and they cannot US Aquavac cannot cite two different statements by themselves that contradict each other and try and use that for defeating summary judgment.
Okay, I got it. Thank you.
You're welcome.
All right.
Okay, and so the last point on this is that they're claiming sand is not muck, right? And what this comes from is that 99, according to US Aquavac, 99% of what they pumped into the bag, or actually 99% of what they took out of the Cove 1, which is the only cove that they dredged, was sand. And Dan McDougall testifies that that's pretty consistent with his visual observation of looking at the bag. It's almost entirely sand. And what US Aquavac is trying to say is that, well, they sent an invoice for removing muck, sludge, and silt. And so they're saying sand is not muck, but it gets pumped into the bag. But regardless of what the invoice states, referring to muck, sludge, and silt, what the contract is for is to remove sediment. And sand is sediment. Silt is sediment. Muck is sediment. It's all sediment that's at the bottom of the lake. And they were paid to remove what's at the bottom of the lake. And once it goes into the bag, it doesn't just disappear from there. The water drains out, but the sediment that gets pumped in, essentially, it's in the bag. It stays in the bag until it gets removed. And so when you look at the contract, it's clear that they had an obligation to remove sediment from the lake. It wasn't just move it from one part of the lake into a different part, but remove it. Remove sediment is what the contract requires. It gets pumped into this bag, it dries, and then it gets removed off site. And so after 59 days, they should have been at approximately, about, over 5,000 cubic yards of sediment. They had already claimed it was 3,800, and it's less than 100. And so it's just, there was no benefit to Longlake that they were receiving under the contract. And so the contract was properly terminated. If you look at the contract termination clause, it's very clear that they were entitled to terminate. And I can pull up that language if you want.
Tell me exactly where I find that.
Yes, bear with me just one moment. Okay, so this is it's page, so the contract is a 76-page document. This is at page 38 of the contract, and it is.
I'm trying to figure out the page numbers that you've been
on
referring to.
The contract itself, it says. So it's Article 10, Section 10.1. It's page 38 of the contract. Bear with me one moment. Let me pull up the PDF of the exhibits, and I can tell you the PDF of that whole exhibit page.
That's the bid.
All right, so it's page 40. So our PDF exhibits were 397 pages.
Right.
This is page 40 of that, and it's section 10.1.
All right, I'm getting there. Okay, got it.
Okay, and so it states, if through any cause other than an excusable delay, contractor shall fail to fulfill its obligations under this contract in a timely and proper manner, or if contractor shall violate any of the covenants, agreements, conditions, or obligations of the contract documents, owner may terminate the contract. And here they were not fulfilling their obligations under the contract in a timely and proper manner. They were lying about what they were doing, and they're breaching the contract terms and breaching the implied covenant of good faith and fair dealing in performance of the contract. And it was an ongoing material breach, and it prevented Longlake HOA from receiving the benefits of the contract. And we asked the court to find that US Aquavac breached the terms of the contract. But if the court feels that there's some questions of fact that preclude it from making that determination, we would ask the court to issue a ruling on what the contract requires, because there's a dispute here as to whether they're entitled to get paid just for being out there, or are they required to remove sediment from the lake.
Let me ask you, Mr. Schwartz, because this is not AIA contract or whatever it's called, but so I'm sort of trying to figure out the various documents that make up the contract, and that's reasonably clear, but under the provision that you just cited, I don't know if there are any general or overarching definitions that might speak to what type of notice has to be given. Because just reading the termination provision on its own, it doesn't look like there's any notice that needs to be given, or any obligation to let the contractor fix the work. Is that how you're reading it, or?
Yes, there is none. There's two different contract termination provisions. The one that is at issue here is the one I just read from. There is a separate contract termination provision which authorizes the owner to provide notice to cure a material default, or I don't remember the exact language, but I could pull it up and we could look at it. But and it provides with 2 days notice to opportunity to cure the defect. And they also did send notice under that provision also. And then 2 days later, they did terminate. But I mean, here, there's no possible way that they could have cured the defect anyway, because they had billed for 59 days of sediment removal, and they achieved less than one. They were 57 days away from possibly being able to cure the defect. But in any event, under the provision that we're relying on for terminating the contract, there is no notice provision. It just allows the contract. It allows the owner to terminate the contract for the contractors failing to fill its obligations. Now, in terms of what is the contract, it's a 76-page document that is at those pages in the exhibit, and it includes the bid forms, it includes the bid documents that came back, and so that's at pages 3 through 78 of the 397-page PDF.
Okay.
And as far as summary judgment is concerned, I may want to address some of what Mr. Thompson states, but I appreciate the court's time on this.
Okay, thank you. Mr. Thompson.
Hey, I'm just trying to click my mute button here, so it's hard to be quiet. So anyway, let's back up to let's one of the things that my friend here said was that there was contradictory testimony from Mr. Pearl. I don't know what he was talking about there exactly. I do know this, and I included it in the motion for summary judgment. During the deposition of Mr. Pearl, which was a long deposition, it's very important for Longlake Homeowner Association, it seems to me, to say that this 16,000 cubic yards was the amount that they're supposed to remove. And I'll get to that in a second. But when he kept asking it over and over again, I included the testimony out of there. And he basically says, you keep asking me to say that, but that's not what's in the contract. And then he goes on to explain that it's a cubic yard contract, a per day contract. And so the way they did this was that US Aquavac submitted two bids. One was a much larger amount of money, and the other one, which Longlake Homeowner Association wanted to do, was on the cheap, which was the per day contract. And it says in it, it's cubic, if the cubic yards is crossed out, so it's per day. So it was understood that we're going to try to get out approximately 100 yards a day, but whether it's one, whether it's 1,000, we don't know. So we're doing it per day, and we're going to work daily, and you're going to pay us daily. And that was the agreement. That bid form is included and is part of that contract. And so they were doing the work. And Judge, I included Google Earth photos in there to show that you can see that that lake was actually getting cleaner. And what's interesting about this is this engineering firm, DPE, was hired by Longlake. Okay, the head engineer's guy's name was Jimmy Garrison. He was deposed by Longlake. They hired him. DPE actually went out and did a study. Now, Mr. Schwartz said that there's nothing to refute Mr. McDougall's report. By the way, there's no testimony from him. He submitted a letter, basically, okay? There's no testimony.
No testimony from McDougall or from
Correct.
Garrison?
From McDougall. There's no testimony. He sent a letter to Mr. Schwartz. That's all. and he claims to be an expert witness. For all we know, maybe he is, maybe he isn't. But the fact of the matter is, DPE actually said they went out and did a study and said they removed like 5,600 cubic yards from the cove. So which is in total contradiction to what Longlake is saying, because they're saying, well, it's only 85 yards and cubic yards. But obviously, that's not the case. And you can actually see where they did the work. And Judge, I showed those pictures and I used the term ex nihilo, all right? Which I'm sure you know, right? It's like how God created the earth, right? This doesn't happen out of nothing, all right? It doesn't get clean on its own. Obviously, they did work. And that's the whole thing here with this. They're making it a little harder than it should be, talking about, you know, that they should have removed cubic yards and what's in the bag and everything like that. When it comes down to it, it's, were they there doing the work, and did the lake get clean? And that's what happened. They had to move sediment. They made it hard for them. Longlake homeowners themselves made it hard for my client to pump stuff, because they were putting up razor wire and things like that around the side, because they didn't want these tubes or pipes in their yards. So they had to like pump from one barge over to another barge. Well, when people see that, they're saying, oh, they're pumping it into another lake. But that's not really what was going on. They had to improvise. There was a so what's in the bag really isn't as important as did they actually do the work, and that's what was done. Now, one thing here that Mr. Schwartz was asking about, and I don't think it's proper actually, is I mean, he's got a motion for summary judgment, but he's asking to make a ruling on the contract itself, Judge, and seems to me that would be a jury issue. Okay. Let's see here. I know you've looked through this, so I don't want to be verbose and go over the same exact things, but the fact of the matter is that DPE actually went in, did this study, said something like 5,600 yards, I believe that was the amount, was removed. They said probably more. Then they sent a letter, their attorney sent a letter to Mr. Schwartz basically saying, look, they were doing a great job and they would have finished if they wouldn't have been fired. And the reason why they're fired, and remember when I was trying to do a motion to add a party, where there's this other, the guy that lost the bid, the company lost the bid, apparently was upset about it, and basically got him fired, came in and said, we don't like what they're doing, look at, and caused a firestorm there and ended up getting him fired. And then they ended up hiring, of course, Riversand is what happened. So there's these, this was actually, the type of case that was, started off simple with the complaint with their unpaid invoices. Okay. And they should still be paid. So,
well, let me ask you a question, Mr. Thompson. Is there, in discussing what Mr. Schwartz has asked for, is there a, in your view, is there a question of contract construction or a conflict of contract construction that the court could make now that would ultimately help this case get tried to a jury? In other words, let me try to be more clear. Do we want a jury determining, look, here's what happened. One side saying this, one side saying this, and we believe this happened. In addition to coming up with a construction or determination of facts that would then inform what the contract meant. and that may be kind of a gobbledygook question, but is there anything I can do now to help a jury ultimately?
I don't think, I think this is ultimately up to, I think, a jury to determine what it really means. And I think, to me,
Well,
it's
that's
clear.
a good plaintiff's lawyer response.
Thank
We
you,
want
Judge.
the jury to decide. I
That's
get
right.
that, but
So,
but-
but here's,
do I have a job here?
yeah, and I think it's pretty clear to me that the bid form was part of this contract. All right, and this DPE, really the contract came from DPE, who they hired, and the bid form was then included in it. And the bid form is really the go-by for this, where it's crossed out. They had a meeting about it, even they crossed out cubic yards and put daily rate, meaning that the cubic yards really didn't matter. It was basically, we're going to try our best to get as much out as we can and clean up your lakes and coves. And that's really what it comes down to.
Okay. So on your response to the motion for partial summary judgment against your client is, yeah, we did some work. We did what we could. We made things better. We should get paid.
Well, in a nutshell, it kind of is. I mean,
Okay.
I don't know if I'd put like that, but but yeah, I mean, yeah, look, that was the contract. That they worked, that they pumped stuff out, whether it's in bags or, goes up into the air, turns into fire, whatever happens, they cleaned up their lakes. They did the work pursuant to the contract, and they should be paid. Whether it's by the contract itself, whether it's quantum merit, however, they deserve. And look, they lost out on the contract, so there's I'm trying to think of the right wording, but what they should have been paid in the future as well. Okay, to complete the job.
Lost profits.
Lost profits. Thank you. They lost profits as well.
Okay. Okay, Mr. Schwartz, I'm going to let you finish us up.
Thank you, Your Honor. So first of all, in terms of no testimony from Mr. McDougall, his report attached to the motion for summary judgment is an affidavit and does qualify as evidence that would support summary judgment under 9/11/56. In terms of the razor wire, that is not, the HOA did not do that. That there was one homeowner along the lake who didn't want US Aquavac coming onto his property and put up razor wire. That really has nothing to do. And even aside from that, it's not why this project they weren't able to complete it, but it's really irrelevant to the question of whether there was a breach of contract here. We address in our brief as to why a contract is a legal question for the court, so that the court can see the law that we cite on that. And in terms of the daily rate being crossed off, so there's two places to look at for this issue. One is the contract itself. If you go to page 66 of the contract, this is the bid form that was returned. And yes, what's crossed off is what's the letter CY refers to cubic yards, and states, instead though, what it states, it says daily rate to remove approximately 16,000. And the 16.
I think we're looking at page 70 of your notice of filing exhibits. Does that sound right? So I'm on the page right above bid summary where it says daily rate.
That is page 70 of the 397 is for the smaller lake. So I was looking at page, say 68. It's 2 pages before that, and it's going to look similar, but it's for the 15,000. Okay. And the reason I'm referring to this one, because this is the lake that they had started off. This is the lake that we got billed for. So it's saying here, cubic yards is crossed off. It says daily rate to remove approximately 16,000. And in the deposition, of US Aquavac on page 19, I'm asking specifically about this clause, and it says question, and it says to remove approximately 16,000. Answer, right. Question, what does the 16,000 refer to? And what he's saying is cubic yards. So this is still a part of the contract that they're required to remove approximately 16,000 cubic yards. Now, US Aquavac is the entity that, to the extent there's ambiguity in this contract, US Aquavac introduced it by returning this bid form that was different than what was requested. And they're framing it as Longlake wanted to go the cheap route. But Longlake, the board has a fiduciary obligation to the HOA. And if they get a contract returned and they're both to remove the same amount of sediment, and one is for about $150,000 less, there's no reason why they would pay more to get it done. And I mean, it was looking back on it, it was a red flag, and it should have put them on notice that there was, that US Aquavac was questionable as to why they would offer to do this for this much less. But it's still to remove approximately 16,000 cubic yards of sediment. And where you can really see this is in the deposition transcript for US Aquavac, and let me find the page number so you can follow along here. So this is at it's Exhibit B, starting at 79. So it's probably page 89 would be page 10. All right. So it's Exhibit B. So if you're looking on the 397 page document, looking from page 88 to 92, and if you go to page 92, which is page 14 of the deposition, it's saying back there. I'm asking, and you're agreeing to remove 100,000 cubic yards of sediment. And I'm saying on average under the contract, you're proposing to remove approximately 100 cubic yards of sediment for each workday, right? And he says, correct. And if you look at the pages before that, it's referring to each of these coves, they're removing, they're required to remove 16,000 cubic yards. Well, for the Northern Cove, the job is to remove, this is on page 12 of the US Aquavac deposition, the job is to remove 11,000 cubic yards of sediment from the cove, right? And yes, he answers, okay. It says, is that a yes? And he says, it's to clean up the cove. Yeah, so they're acknowledging for each of these coves, there's a specific amount of sediment. Now, it's not like they're required to remove exactly 100 cubic yards of sediment per day to get paid for that day. But over time, it's clear, and in each cove, it's clear, and they've admitted this. This is why the testimony that they're trying to say it's only a daily rate is contradictory to their own deposition testimony. They're admitting at pages 10 to 14 that they're required to remove 11,000 cubic yards from this cove and approximately 100 cubic yards per day. It just didn't happen. And I know that that's not in front of the court at this point, but it's clear when you look what happened at these. Well, I'll just leave it at that. And I think the court can understand they've agreed to remove a specific amount of sediment. They weren't close to there. And there's just no explanation as to where it went. And just finally, in terms of the claim about the Google Earth photograph, yes, you can see sediment was moved from the Northern Cove, but it doesn't show where it went. And so we have actual testimony from witnesses in deposition stating they observed the sediment being moved into other areas of the lake. Now, what US Aquavac is trying to show is they've got photos showing sediment was moved from one spot, and that DPE, the engineer that Longlake hired, said that US Aquavac was doing the work. But there's just because they were moving sediment from Cove One, they're not allowed to get paid just because they move it into a different part of the lake. And the bag, again, US Aquavac testifies that it went into the bag, and that's cited. I could tell you the site if you want, but it's in our brief, the citation. And they're not saying that the sediment from the lake went anywhere other than into the bag. They're just saying it shrinks from there. It's just, it doesn't happen.
Let me ask you a question, Mr. Schwartz. Sitting right now, 10:50 on the morning of April 20th, 2022. Do you know what this contract means?
I know that the contract requires US Aquavac to remove approximately 18,000 cubic yards of sediment from 2 lakes in Longlake.
Okay, so let's say that you're telling me you know what it means.
Yes.
And so I think I hear you telling me I know what it means. The facts are undisputed. The plaintiff didn't comply with the contract. Plaintiff loses. Okay, is that what I hear you saying?
Yes, Your Honor.
Okay, now let's change that a little bit. Let's say you know what the contract means. Here's what it means. Can't really say whether it was complied with or not. The jury may understand that, may need to decide that. But judge, you have to tell the jury what the contract means. Is that potentially a second outcome here?
Yes, if you find that there's a dispute as to whether the contract has been breached, then it would be up to the jury to make a factual determination as to whether the US Aquavac actually complied with the terms of the contract.
Okay. I hear your argument. I don't think you know what the contract says. I mean, I think you're saying there's a conflict in what the contract means.
No, not at all. I'm sorry if I'm being unclear, but I am certain that the contract requires them to remove approximately 18,000 cubic yards of sediment from Longlake, from 2 lakes. Okay. Now, the lake that is at issue here is the larger lake. It's the lake that has 16,000 cubic yards of sediment. Okay, there's no dispute that the bid at page 66 of the contract is a contract term. Okay, that's undisputed. That US Aquavac testified that that's a contract term. US Aquavac in pages 10 to 14 of their deposition testified that they're required to remove approximately 16,000 cubic yards of sediment from the large lake. They testified they're required to remove approximately 11,000 cubic yards of sediment from the northern cove of the Long Lake. It's undisputed they're required to remove sediment from the contract. It's also undisputed, also at pages 10 to 14 of their transcript, that they're required to remove approximately 100 cubic yards of sediment per day. Okay, that's like the material terms of the contract here, that plus the termination clause. Okay, and so all of that really should be undisputed. And the only dispute on any of that here is the contention by US Aquavac that it's a daily rate contract and there's really no requirement to remove any amount of sediment from the lake. Now, we contend that is contradicted by the contract language itself and also contradicted by the deposition testimony of US Aquavac. Okay, so in terms of the legal question of what the contract requires, it's to remove a specific amount of sediment from the lake. Now, so that's the contract. What does the contract mean? In terms of whether it was breached, what we're saying is that there actually is no material facts in dispute because even though they're trying to say they're not required to remove any specific amount of sediment, they've admitted that they are, and the contract itself says that they are. So there really shouldn't be a jury question as to whether they're in breach. But if this court finds that there is some disputed question of fact as to the breach, we're still alternatively asking the court to state what the contract means, because that's a legal question. And only if the contract itself on its face is ambiguous, and then after following the rules of construction for contract interpretation, only then, if it's still ambiguous, where you can't look at it and say that, how would a reasonable interpretation, if it could be reasonably interpreted in different ways, even after following the rules of construction, then it's up to a jury to determine what the contract means. But we don't think that needs to happen here. Did that
So
answer your
here's what I
question?
think. Here's what I'm hearing. And so go from there, Mr. Schwartz, in correcting me. I've got multiple types of documents put together by contract language. They're to be read together. So I've got multiple types of documents combined to make a contract. That contract includes handwritten changes. Those handwritten changes and other potential parts of the contract are being interpreted through deposition testimony and possibly affidavit testimony. And so you want me to go 80% of the way towards deciding this case and say, here's what it means. And jury, you just have a little bit left to do at the end. Is that what I'm being asked to do?
Assuming that you find that there's a factual dispute as to what, because initially we're asking you to actually find that there's a breach of the contract. Sure. Assuming that we're getting past there, then yes. So I'm asking you to actually initially, we think you can just look at the four corners of the contract itself, which includes, it's the entire 76-page document, which includes the bids. That's the contract.
You spent a lot of time telling me what's in these depositions. How's that the four corners of the contract?
No, well, this is the first step, is you would just look at the contract itself, okay, without any extrinsic evidence. But then, even if after that, if there's still some ambiguity, then you would undertake the rules of contract construction. Okay, and so that would be some of that's in the code, some of that's just common law construction that a court would use to. This is step 2 of the contract interpretation. If you can't determine it just from the language in the contract itself, you're going to look at other sources, and initially, so step 1, the contract itself. Step 2, you're going to apply the rules of contract construction to resolve any ambiguity. Okay, and that would be I could pull up the code section here, but there's somewhere, I don't know if it's at 13-2-1 or right after that, but it goes through the rules of construction that a court would use to interpret a contract. And that would also, the cardinal rule, the number 1 rule that you're looking at there, is determining the party's intent. And that is relevant to determining whether, what does the contract mean? But then if you follow all those rules of construction, and some of those rules may not apply, some of them might not help, but after applying the rules of contract construction, if you still determine that it is ambiguous, that it's just unclear as to really what the parties intended, what the contract states, then it would be a question for the jury to state what it means. So I think though that when for step 2 of this, right? So let's just assume that you think that there's some ambiguity based on the 4 corners of the 76-page document. Then you could look at extrinsic evidence, including the deposition testimony of US Aquavac as to what this means. And they're acknowledging, yes, they are supposed to be removing approximately 18,000 cubic yards of sediment from the 2 lakes. They're supposed to be removing approximately 11,000 cubic yards of sediment from the northern cove, and that they have approximately, that they're supposed to be doing that like approximately 100 cubic yards per day. And it's undisputed that what they're required to do with the sediment from the lake is pump it out of the lake into this large geotextile bag that's on the shore, let it dry, and then dispose of it off-site. And it's okay. Thank you, Your Honor.
Oh, I didn't mean to be so abrupt, but I appreciate it. I'll let y'all know just as soon as possible.
Judge, can I say something real quick?
What?
Okay.
No, I don't need another argument. I mean, if you're getting ready to tell me something like, it was good seeing you,
Well,
we're anxious to hear from you, that's great.
That'd be nice too. No, I was just gonna say something that Mr. Schwartz said, was it said it's not like they needed to take out 100 cubic yards per day. I think that's telling, because that's not what the contract is. That's what I've been saying the whole time.
Okay. All right,
Good
y'all.
to
I
see
can't
you.
thank you enough. That was great. I really enjoyed hearing from everybody, and thank you. And I'll get something out just as soon as possible.
Thank you.
Thank
Judge.
you, Your
Oh,
Honor.
wait, let me take us off YouTube.